Okay, so we are going to turn our attention now away from the free exercise clause primarily to the establishment clause of the First Amendment. And we're going to discuss important cases in the court's history in terms of defining what is an establishment and also determining precisely where it is that government crosses a line from mere recognition to favoritism for religion or for a particular religion. So these are the words of the clause in the First Amendment. It's the very first words of the First Amendment saying, Congress shall make no law respecting the establishment of a religion. But what does that mean precisely? What does it mean for government to establish a religion? At different times in our history, it's meant different things. When the United States was made up primarily of colonies, establishment of religion meant the official sanction of a particular church. At other times, it has meant other things, like the requirement that by the state that all individuals be in church on a Sunday, that everyone attend church. No particular statement as to what church, but just a requirement that people be religious. Some people would say that that's not an establishment of religion. That the original meaning of those words was to establish an official religion for the state, but any endorsement of religion wouldn't violate the clause. On the other hand, you might have people on the other extreme who would say that any support for religion or religious functions is a violation of the Establishment Clause. The court has maneuvered its way between those two extremes in terms of accommodation and endorsement for many years, and it's been very difficult. It's almost as if the court is deciding on a case-by-case basis whether some action by a government endorses religion or not, even though the court has articulated tests. So this clause is actually in conflict with the free exercise clause, and the question there is why. Sometimes it comes into conflict, and I can tell you why. At least in part, I think the reason is that these come into conflict is that sometimes it requires government to recognize religion in order for people to exercise their religious freedoms. So, is government endorsing religion or establishing religion by recognizing that Americans have been and remain a religious people? That is also part of the the minefield that the Supreme Court has had to negotiate. So the key question here then is, how strict should the separation of church and state be? We recognize that that clause right there, Congress shall make no law respecting an establishment of religion, that calls for separation of some degree. But how strict should that separation be? So there were three views held by framers on this matter. The first one is the analogy that most people recognize here is the wall of separation metaphor. It is not in the Constitution, but it was articulated by someone who had a good deal of influence on the framing of the Constitution, Thomas Jefferson. In a letter, he noted that a wall of separation should exist between church and state. The second was, as I said earlier, the state may not prefer one religion over another. It could, however, do something like require people to be religious and let them choose their own religion. The other was that government may not establish a national religion, and certainly that would suggest that government could do other things besides establishing a single accepted religion. The court's view has basically been Jefferson's, and that there should be a wall of separation between the two, but that wall is lower or higher at different points depending upon what is being regulated and what the relationship is between the church, a church and state. So there have been exceptions, and the wall is not uniformly the same height. So how do you read it? How do you go about reading the Establishment Clause? What preferred doctrine do you endorse in interpreting this important clause? Maybe keep that in mind and think about that as we go through this, because your writing assignment is about religious establishment and free exercise. And it might be good to develop some thoughts about what is the most appropriate way to interpret both of those clauses. The court didn't hear many cases prior to the 1940s. I think the explanation for that, of course, is that the court was concerned primarily with economic rights, and that it was content actually to leave the states alone when it came to religious practice. Also, there was a lot more uniformity of religious practice in the United States than there is today. However, it did hear a case, 1899, called Bradfield versus Roberts. Now, this early case involved an appropriation by Congress of some money to support a hospital in Washington, D.C. to treat indigent patients, so poor people, people who are experiencing economic adversity, could be treated at this hospital, in particular those who had contracted certain contagious diseases. And this hospital in Washington, D.C. that was receiving this federal money, $30,000 in 1899, was run by an organization, a religious order called the Sisters of Charity, Roman Catholic nuns. The policy was contested in that while that might be a good idea to support hospitals, the appropriation of the money was a violation of the Religious Establishment Clause. The court says, sorry about that, the court says that some aid to religious entities is okay as long as the purpose that Congress has in mind is a secular one. And here clearly it was secular. Congress wants to care for individuals who are the most at risk for disease, and wanted to ensure that the public health was maintained, that these contagious diseases did not break out into a larger and wider area of distribution and people getting sick. And so the court upholds this as an appropriate use of money by Congress. So the very first case right out of the gate is one that allows government to recognize religion and the role religion plays in society might be a secular one. Okay, the next case is not until 1947, is Everson versus Board of Education, and this has to do with transporting children to and from school, both public schools and private schools. And the question was, does reimbursing parents with tax dollars for transportation costs for children to private religious schools violate the Establishment Clause? The court says no, and it's a very close vote, 5-4. Justice Hugo Black writes the opinion for the majority, which is excerpted in your text, and he writes an interesting opinion. It is very separationist in its logic, but accommodationist in its conclusion. Let's look at that a little more closely. He says, the First Amendment only needs to remain neutral. It only requires government to remain neutral. Here, the state does not contribute money directly to the schools. New Jersey doesn't breach the high and impregnable wall between church and state by ensuring that children get to schools safely. The court looks at that and says that is a legitimate governmental purpose in ensuring the safety of children moving from home to whatever school they're attending and back again. But if you look at the opinion, it uses some very, very strict language about the high and impregnable wall between church and state, and ensuring that government does not corrupt religion. So a couple things you should know. Everson incorporates the Establishment Clause, so we're back to incorporation doctrine again. It incorporates the Establishment Clause. In other words, Bradfield v. Roberts was about a congressional appropriation. Everson was about a New Jersey policy, a state policy. And so the court first has to decide whether the Establishment Clause even applies to the states. And it says, yes, it does, through our old friend, the Due Process Clause of the 14th Amendment. Then the court uses this metaphor of a wall of separation to interpret the clause, and uses this strict definition of support for religion to come to an accommodationist outcome. I guess one would say that was a liberal outcome, that there should not be a strict demarcation between government and religion when it comes to things that policies that have a secular purpose. So this actually raised more questions than it answered, this case did, in particular because the logic used by the majority and the dissenters in this case was exactly the same. And using that same logic, they come to very different conclusions about whether this policy passes constitutional muster. After Everson, we see the battle lines kind of being drawn, the court sorting things out. So in some instances, the court upholds support for parochial schools or religious private schools. Busing, the provision of books to religious schools was just fine. Once again, providing buses, not good because they might be used for things like field trips that were primarily religious in nature, but the state supervising the transportation of children from home to private schools is okay. Providing books to religious schools. Providing books was okay as long as the state bought them. The state could not hand the money over to private schools to purchase their own texts because they might purchase texts that have religious content. So even where the court upholds these policies, it's particular types of policies that the court upholds. The court then goes about to strike down other types of policies. Prayer in public schools and the mandating teaching creationism in the public schools. You'll notice that on the first bullet where the court upholds some policies, it has to do with government providing direct aid to religious schools. Where it strikes others down, it has to do with religion entering public schools. So is this a clear standard? Is this a clear test? In some ways I think it is. In others it creates some confusion. It's clear what the court has in mind. It wants to allow government to provide support to private religious schools for things in which the state has an interest. Getting a good education in math, English literature, writing, other secular topics, certainly. Getting safely back and forth to school, absolutely. Giving money directly to these schools for that kind of support, no. State-sponsored prayer, not private prayer, which by the way has never been attacked in our schools with any success before the Supreme Court, students praying and the like on their own, but state-sponsored prayers that were written by the state, approved by the state, teaching a creationist doctrine, the court strikes those down. Okay, so after Everson we get a series of cases like Abington Township, in which the court strikes down the recitation of Bible verses and the Lord's Prayer. That case is excerpted in our text, and this case comes after the successful effort to strike down the recitation of state-written prayers in public schools. They come back and they challenge some other common occurrences, as the text says, reading from the Bible and the recitation of the Lord's Prayer. Now, obviously, the Lord's Prayer, written by Jesus Christ, not written by the state. So, is that okay? the court says no. And in doing so, it articulates a standard. The law must have a secular legislative purpose. Where have we heard this before? It's a theme that runs all through the jurisprudence of the topic of our course. All that due process and incorporation case study, and neutral purpose, secular purpose. It also runs, in particular, runs through the free exercise cases, and here we have the court articulating it with respect to establishment. Whatever law the state passes must have a secular purpose, and its primary effect must be to neither advance nor inhibit religion. So that's a two-pronged test that the court articulates in Abington Township. It applies it in Board of Education versus Allen. As I mentioned before, buying the books for religious schools and lending them to the schools is okay, has a secular purpose, it doesn't advance religion. The question is, we move on to talking about the Burger Court, the question was whether this should stay the standard once Warren left, the Warren Court dissolves, and Chief Justice Warren Burger takes over. Three key points here. First of all, the Burger Court didn't know exactly how to apply the test. So when is it precisely that the state has met its burden for having a neutral, secular legislative purpose? Looking back at the primary effect prong, when is a primary effect neither to advance nor inhibit religion? Secondly, other groups, including the ACLU, who are bringing these cases, wanted definitive answers. They wanted a clear standard. They wanted the law to be clear, and the court was having difficulty providing us that clarity. And also, you should note that the Chief Justice himself wrote close to 70% of the opinions in this area, and he had a profound influence on it. It wasn't one that created a lot of clarity into the future. So what we get then is a new test that the court codifies in a later case we're going to talk about in the next lecture. But in 1971, in Waltz versus Tax Commission of New York, the court upholds tax exemptions for religious organizations, says that those do not involve an establishment of religion, and it gives us an additional prong that it adds to Abington. So it adds the excessive government entanglement prong. Beyond the purpose and primary effect of a law or policy being not to inhibit or advance religion, government can't entangle itself with religion. So let us think, for example, of a government that wants to give tax exemptions to religions, and it has a special position at the county clerk's office. A representative of the church has to go down and justify to this person that they are, in fact, a true bona fide religion. Is that excessive entanglement, right? Well, okay, so the purpose is secular, right? We want to give tax exemptions. If anything, it's hurting the tax base of the government. The purpose and primary effect is neither to advance nor inhibit religion. I think there might be some arguments about that, but let's assume, for example, but does having a person who determines whether a religion is religious enough to be considered a bona fide religion, is that appropriate? That's why the court adds the excessive government entanglement prong. Okay, so yeah, and I'm sorry, there's this question there. Would this bring down the Abington standard, the addition of this third prong? And we'll have to answer that question in the next lecture. Thanks for listening.